We are recording. You may begin.
Hey, thank you for being here. It is October 23rd, 2025 at 4:02, and this is the meeting of the Land Use Review Board, a special meeting where we will discuss the draft appeal study, which was passed to this board for by the legislature as part of Act 180. So Brooke Dingledine has been the lead on this, and so I'm just going to turn this over to Brooke. Actually, though, first, I'm Janet Hurley, the chair. Brooke, will you introduce yourself?
Brooke Dingledine, board member.
Sarah Hyde, board member.
Alex Weinhagen, board member.
Sultan, board member. And we have John Grothman in the room. Thank you, John, for being here with us. And you people online, I can't really read it from here. It looks like Annette and Zachary. Okay, thank you for being with us. Go ahead, Brooke, take it away.
Do you want to, I think on the agenda, we actually had a comment on non-agenda items.
We do? Okay, sorry, I'm not looking at the agenda. Do we have any public comments on non-agenda items? Don, Annette, or Zachary, anything that you want to say about something other than the appeal study? The board. Looks like no. Thank you. So now I will let you take it away, Brooke.
Thanks so much. The appeals report has been drafted. I want to emphasize right to begin with, this is a working draft. There was a great deal of information to collect and organize and explain. And but we wanted to get a draft out as quickly as we could, since we have a deadline of mid-November for the actual submittal of the report. So admittedly, there are sections that I had not yet gotten to summarize, explain, develop, or analyze. And so we're trying to fill the gaps on those conversations. I have received some email comments, and they will be included, of course, with all of the comments that we collect on this draft report. And some of the points are very important, and we will be, all the board members will be looking over the written comments. For example, it has been voiced that the report sounds dominated by the lawyers' conversation during the appeal study, and the housing developers were wanting their concerns, their positions, and their recommendations better voiced through the actual report. And in giving feedback and explaining to the stakeholder that brought this up to me, we are working on a housing section to talk about the volume of those appeals for zoning as well as Act 250. I know that most of the report is really talking about the Act 250 appeals process, but that point was very well taken because we want to make sure that everyone's voices are heard. While the report itself and recommendations are the board's, we want to make sure that every one of those contributions are fully displayed and that they are also responded to and discussed, because there were many issues that were raised. And I am keeping a laundry list and working through them methodically to make sure that any of the issues that also have been identified, discrete issues, like what about the petition appeals standing issue in the zoning context, that kind of thing. So anything that you identify as missing from the report or that you would like to see more analysis, or certainly your comments, your arguments, your response to this report, we are in the process of making a kick in developing it. So all comments are welcome, and I will be quiet now and I will open up the floor so that we can hear from you all. Hear what you have to tell us, since we are in the process of trying to figure this out. and there have been no determinations made by the board. We have been discussing this. They have been guiding the report. But we're doing the best we can to make sure that we cover it soon. That's because this is a very important study of an issue that has been debated for years, if not decades. So we want to do the very best that we can. So I will go ahead and open it up. And race to see whose hand goes up first.
Thomas, do you have any comments? That's where we are on the appeal study.
Give me my chance to sit down.
I will wait. Choose not to be first.
I'm happy
Okay.
to kick things
Go
up,
ahead, John.
but I really came, really, I didn't know that the public was, I really wanted, because I've been on the stakeholder group, so I really wanted to hear, public comments if there were any. I'm realizing that, I guess I would say to the board, this is a tough issue to get public comment on. This is a fairly esoteric issue that does have a pretty big impact, but, I've been involved with public policy issues for a long time, and this is a harder topic, I think, to get people to come out and talk about, the appeal system for certain permit appeals. But I didn't know who would come out. I wanted to hear the public. I'm not gonna, I've said a lot during the stakeholder process on behalf of the NRC, especially I'm John Groveman. I'm the Policy and Water Program Director for the Vermont Natural Resources Council. I'm also here because this is, an issue that's really important to the NRC and something we've worked on for a very long time. So I wanted to just be here and be present, for all the parts of the process, including this one. We're looking at the draft report. We'll provide comments. I think we have until the end of the month. Is that right?
Sure.
But I will say this, that I'll say that, I think if the report is going in the right direction, I think we'll recommend, some improvements to the report and some additional things to consider. And we have been talking with the housing groups, and I'm glad that some of them have even, I know that in talking to the housing groups that, and it's also, I think, why it's hard to get the public to come out. They're not lawyers, and it's hard not to have lawyers dominate a process about where do appeals go and how do appeals work. But, this is a system, and like in my view, analyzing this issue, this is really about what is the best system for reviewing appeals and reviewing projects. A system that's tied into the initial permitting that happens, whether it's at the local level or it's at the district commission level. And I think in talking to the people in the housing community, I don't know exactly what they sent, but I think that they feel like, and it's been refreshing that as a lawyer, as someone who's a lawyer who's participated in these appeals, that they're like, we're kind of tired of the lawyers telling us like what works for us as developers who've had projects go through the system and seen firsthand like what works and what doesn't work. And my understanding is that they do, that the people, at least in the housing community that we've talked to, do think, and this lines up with the NRC's general position, that having appeals go to the board creates more flexibility, creates more opportunities for separating the more complicated appeals for the simpler appeals without running every appeal through a court process, which is very complicated. And something that, as a lawyer, I've been involved in the court process. I've been involved with board processes, but there's just no way around that. All the rules of procedure at the court, all the rules of evidence at the court, all the motion practice at the court, that's just part of being in superior court. There isn't like a separate process. And, the way we've looked at in terms of the systemic approach is that a system would work better if it was, when you're talking about administrative appeals of administrative decisions, which permit decisions are, that having them run through an administrative appeals process creates more flexibility. It creates people involved in the process who are really knowledgeable on the issues, in this case, land use. And, there's a lot of land use expertise on the board in terms of zoning and planning. There's expertise in terms of Act 250. I think over time, the board will develop more and more expertise in Act 250 as you administer the program. And so we've always thought that would be a better system because of the flexibility and the expertise that the board brings to it. And then the details, all the many details of how you would construct a system, that's what we'll be commenting on, I think, in the report. And, but generally, I think it is heading in the right direction. We're still like kind of going through the fine details of it, but I appreciate all of the work that the board has put into it and all the work that Brooke has put into it, and the stakeholders. So I guess that's really all I would say at this point, and we'll submit detailed comments for the end of the month deadline.
John, let me ask you a question. I'm going to put you right on the spot. Because you and I had a prior conversation offline about my concerns of the resources necessary versus the volume of appeals, at least within the Act 250 program. And I was hoping that you could address that, like the discussion that we had, because I think the points that you made were very important. And I'd like the board to hear about the system that you are advocating for, as opposed to looking at it dollars and cents per how many cases we might be processing.
Yeah, sure. And we'll address this in a specific comment for still, but in terms of specific recommendations, and I think we'll provide some ideas for different options in terms of bringing resources to hearing appeals, if that's what the report continues to recommend. And we hope it does. Yeah, I mean, I think, the way that I look at it is, first of all, I think it's important to take a step back. And right now the court has, all the appeals and all the enforcement. They have 2 judges and they have two law clerks. That's what they have, which is not a lot of staff. Yes, they don't have all the planning responsibilities that you all have, which really I understand has to be balanced in and is a concern. But I think that as the LIRB does its work over time and gets through this really important kind of first phase of regional plans and future land use maps and Tier 1B and Tier 1A applications, you'll get more efficient at it. And also, having been through a round, it'll be like amendments and changes to the maps and the 1B and 1A proposals. It won't be the really intense kind of amount of work that you're dealing with right now, which we're following that too, and the Tier 3 rule and all the other initiatives that you're doing right now. And as that work levels off a little bit, I think part of the idea of having a 5-member professional board is that you're all like, you're full-time workers. Like, we've never had that before. When we've had the environmental board, there was 1 chair, there were 8 volunteers that were just never there. And I think the idea is that, and the Public Utility Commission, there are non-lawyers that are hearing officers that hear matters, and there are lawyers that help draft the decisions. So I think that, and we'll be making specific comment on the resource proposals that are embedded in the draft, but we think that there's a way to use the board, all of you, to engage in this work, and your attorneys that you have, and maybe one more attorney, but I think we can see a vision of implementing the board hearing municipal zoning appeals and Act 250 appeals that wouldn't require the amount of resources that are called for or kind of set out in the report. I think these are just issues that need to be talked through, but I think there are different ways to resource this, and I think that right off the bat, like I said, the board would have significantly more resources than the court has now. And then that flexibility of being able to work through simple appeals more quickly. I think it could be done with less resources than I can see that the board is thinking about. Totally understanding where you're coming from. Totally understanding the amount of work that you're dealing with right now. Totally understanding the concern about how involved is this all gonna be, at the end of the day.
There is a spectrum of thought on that. Right now, and we haven't finished that conversation.
May I
Yeah.
ask a follow-up question?
Yeah.
I think just that point is, we've done our best to collect data to try and make our decisions from. And it sounds like, you're advocating for a point where there might need to be less resources. And so I welcome data that you have around that you can provide us so that we can use that for some things that are using to inform your opinion on that.
Mhm,
I think it
sure.
would be helpful, if you have not already shared with Brooke, just because it's hard to quantify. And I think we're working to get the best data that we have to help inform our decision. It sounds like you have arrived at different potential, informed decisions, so be curious as to how do we get there.
No, I appreciate that. As we work on our comments, I think the data in this case should be compared to sort of other similar, administrative appeals, entities, and how much staff they have and what's their volume of work. And we have looked at that, although I don't think we haven't quantified it, but I could be more specific about that. And a lot of this is based on experience, just like having been before worked with the Public Utility Commission, worked with the old Water Resources Board and the old Environmental Board. But I hear you, we'll try to do that. And I understand the difficulty of, it's really all, we're trying to make educated decisions, but it's not a science, But I obviously the sensitivity around you having enough resources to do the work and how hard it is to get resources right now to for any governmental program. So, but you don't want to shortchange anything. I mean, I think this is in the report. I think that we have shortchanged the appeal system for a long time. Like when we made this change, when we took all of the permit appeals and we put them at the court 20 years ago, and the decision was made to go with 2 judges and 2 law clerks. I mean, we've never changed that over time. It's pretty remarkable. And I think that was the wrong decision. And I think that the system would be better for the reasons I said, but I think you'd have more resources at your disposal and talk about how to add to that. But we'll be more specific in our comments. So.
We've been trying to use the data that we have, but the biggest challenge that we have is that many of the data points are moving targets were just non-existent because we don't know what's going to happen with Act 250 appeals. If we're giving up jurisdiction over tier 1A areas, well, they theoretically should go down, but it is not a science. It's almost a guessing game to some extent. So that is why during this conversation, we feel more comfortable with the smaller universe of Act 250 cases because we know it's been very consistent in terms of how many are appealed over the last several years. So we at least have that to hold on to. Now, when you look over to the zoning area, that is 20 cases a year that are housed out of 60 total appeals. And, so we're talking about a bigger volume. And some of the housing experts have said, what happened to taking all the zoning? And so this notion of checking in 2 years is so that we can get through the majority of the really, drinking out the fire hose kind of, picture of all of the different studies and rulemaking and all that to get past the majority of that, because that's very work intensive and personnel intensive. So that, yes, we are then on footing to be able to consider taking the Act 250 appeals. But at that moment in time, we will have some better information, not perfect and not complete by any stretch of imagination, but to check in with reality as to what's happened, because right now we're predicting things we have no information about. And it's very
No, I
concerning.
understand that. I think from the housing groups that have been part of the stakeholder process, I think you're hearing that because they really, they're thinking like, they like to see all the housing appeals go because they don't still think the current system is working. And in the conversations that I've had, and they can speak for themselves, obviously, in their final comments, they've made the point, which is very logical, that like, it doesn't, ultimately, we shouldn't be like kind of sending things off in different directions. It would just be more consistency if like, at least the category of housing appeals would all go to the same entity, and then that entity's expert in it, and you're getting decisions that are internally consistent. So I think that's their desire. I do think another part of the resource question is I do think there would be a long phase-in period. I think both to let the LURB do the really intense, important work you're doing now, and just to make a transition, it takes some time. So that, I think that's another area where we think we could talk about how long that transition is, and during that transition period, like how many matters do we move and how do we do it? I think we'd be more open to a longer transition period, and then at that point, at least with the housing appeals, so you're not sending things in different directions. They would start with all going,
So
to the
one
same
of
place.
the aspects of our recommendations, John, is that the applicant would be able to ask that they consolidate the local permit with the Act 250 appeal. So insofar as housing projects are Act 250 jurisdictional,
Mhm.
they can choose to bring the local permit appeal together with the Act 250.
Yeah, no, I saw that. Yeah, I'll stop talking and we should let Annette talk and Thomas talk, but I saw that. I think I think we would like to see it not just be the applicant's choice, and we'd like to see all the matters moved, and whether they're consolidated or not, I think the consolidation question is important to address because a lot of parties over, as Brooke noted, the many, many years we've been discussing it, has said consolidation is important. So I do think creating that opportunity is important, but there's, from what I hear from the housing developers is there are a number of just zoning appeals that don't involve Act 250 that have gotten caught up in the process, and so they don't want to just tie it, I don't think, to the consolidation only, but.
Before I go to Annette, I just want to ask you, so when you say you would like to see us take all the appeals, are you saying all the housing appeals?
Yeah.
Not all the zoning appeals?
Yes, the housing appeal. I think that's the start. I mean, I think that's kind of our thought about a way to not take all of them, so it does limit the workload, but at least it's the whole category. So you'll get just the same people making decisions on all of that category that there's so much focus on right now appropriately, because people are so concerned about, the housing issue and wanting to pull every lever possible to try to like move housing projects forward. So yes, so to start with that, and if it worked out and with more data, then we could have a conversation about commercial and industrial, other types of zoning projects.
Thanks. Annette? Welcome.
Good afternoon. I will note I am a member of the stakeholder group, and so I've had opportunities to participate in that realm. I'm going to speak to the things that I heard in the last two meetings that Alex has very capably held about Tier 3 last night and the night before. I think there were about 40 members of the public present at each one. And also I attended the Legislative Rural Caucus Committee meetings the week before last and the week before that, where Alex presented on Tier 3. So I'm going to make an effort to channel the public, since there isn't any public present except Thomas. There was the meetings the last 2 nights were very good. There were a lot of good comments, and there was a common theme that I think is important to expand the appeals report about, and that is the equity issue that is coming up, where there is this idea being voiced that well, it looks like you're giving all the benefits to the urban areas and the rural areas aren't getting anything. But you're targeting us more. And I think that that is something that the legislators are going to be very concerned about too. I can see building support for the LURB hearing appeals because the process could be less onerous than court. And so part of what I'm suggesting has to do with framing, but it also does have to do with the report addressing this equity issue that is being raised. That by, I mean, I don't view the switch to municipal permitting to be some sort of gift. I think it's opening up a can of worms that frankly I don't think is going to speed things up and may result in more appeals. But what we are hearing from the rural areas is that you're placing more burdens on us. It's a taking. It is affecting our property rights, and what's in it for us? And so, if there is, and there are also very legitimate issues being raised about the concerns that the rich people can just, they don't care about the road rule and they don't care about Act 250. They can just come in and pay and build anything they want and get their mansions at the end of their 2,000-foot road on top of a mountain. It's just money for them. But for us with families who are farmers who want to carve off a piece of land for our kids, and this creates a real inequity economically. And I think this appeals report needs to address that aspect of it in a way that is realistic, and how having appeals heard by the Land Use Review Board can be less burdensome than if one were to go to court.
All right, and that is Sarah. Question for you. I think you just alluded to the end, you alluded to it earlier in your discussion about moving the appeal process would be easier. And I think, and you said less burdensome, and for whom?
For the applicant and for anybody who is affected by a project. That's kind of what surprised me about the Morrisville public comments, which were really good. That I will admit my bias has been considering what it's like from the perspective of somebody who is a neighbor of a project, but also for the applicants, for somebody who has found themselves in Act 250 and can't afford it. There was also a very interesting comment by a realtor that you can't find an engineer to hire anymore. It's similar, I guess, to aesthetics experts. They're just vanishing. But the Bennington realtor said that you can't find an engineer to hire to even do the Act 250 work. So it is something that I am recognizing needs to be made more accessible. And I want to give Alex credit in both of the meetings for saying, look, once we get past all of this work that we've been told to do by the legislature, yes, we want to work on the program itself. And that's really where the Land Use Review Board can improve this system, because it hasn't had anybody paying attention to how to make it work for everyone. And I think it can work for everyone. But right now it is viewed as a monster for developers and not really that effective for people who are affected, because there are very few hearings, and if there are hearings, they're really challenging for people to participate in. So I don't know if that answers your question, but I'm looking at overall.
And so I'll ask it, so a little bit of, I'm wanting to make sure that I'm hearing this correctly from you. So I think what I'm hearing from you is you believe that the LURB takes on appeals that'll be easier for all involved in the process. However, Act 250 is also a monster that people will try and avoid. So
that's the way it's viewed right now.
The cure, and then this illness are sort of like the same thing.
Um, I think that the Land Use Review Board has the potential to create a process that will work better than what we have now. I think that the current process is viewed as the monster that it should never have become. I mean, I will say over and over, Act 250 is a good law, and a lot of thought went into creating this regional review process, and it really needs to work. And the appeals process also needs to work for everyone and not be the onerous thing that people have now come to think that it is. So whether it's through the ombuds office or through a design of a process that specific to appeals that is not as legalistic and paper pushing as court, that makes it more efficient, I think that that can benefit everyone.
Thank you. I think that's very helpful, and I think what you ended on, I think I'd like to highlight as being important, is having been around when we went to the environmental court model 20 years ago. And I think what was spoken to earlier was about resourcing, and that we gave resources to environmental court 20 years ago, and those have been sort of static. And I think where you landed on with the ombuds person is something that I think Brooke has addressed in their report as being an important part of resourcing and having that person that can outreach, especially to pro se folks that are coming in through the process or representing themselves. I think the resourcing and getting it right, and also the lead up with the new model to the regional reviews, and sort of, I think was spoken to working this through and having that check-in to see and to make sure that we get it right. Because as you can tell, resources don't change over 20 years. So it's best to get this right at the onset, and maybe perhaps take a little bit more time with that. So thank you. I think those are some of the things I heard. I think what I'd like to address Brooke too is there's so much that we're hearing on tier 3 and on all the other fronts. And you're so far down the pipeline. I think your report does address some of these stigmas of Act 250. I don't think that this needs to be another chapter in it. I think that's something that we as a board have talked about doing through rulemaking as sort of next steps. And so I think that there are other avenues to pursue that rather than addressing it.
I would like to suggest that based on what I'm hearing the legislators saying, that everything that you can do in your reports to the legislature to articulate the understanding of the potential for this imbalance between rural and urban and between the wealthy and the less well off will be helpful in gaining traction on what you're proposing.
Yeah, and I do feel that there's a section of the report that we need to develop on the ombuds office for a specialist support situation, specifically about the appeals report. And I think that it's really important what you said about the equity and difference between, or the perception at least, between rural development and, you know, the more targeted downtown areas. But also what we have heard are, that ties right into what Annette is saying, is that small developers don't have the same resources, and they would benefit greatly from being able to have more guidance through the process. So that is the thing that I want to make sure that people understand is, and we haven't given a lot of ink yet to the ombuds position, but this is not to help NIMBYs make things more difficult. And I want to be sure that that is not the impression. It is to help everyone so that the process becomes more accessible and more efficient. But the focus on applicants, I think, is really important because we've heard that in various venues, certainly in the wood products, and we've made a commitment to further explore that. So I really appreciate your comments in that, because I think that's something that we really need to focus on in that portion. And we do need to develop it so that we can better articulate what actual role would help for Act 250 and our program.
So we're gonna go to Thomas and then Zachary.
Thank you. Hi. Thank you for taking comment. Start over. Good afternoon. I'm Thomas Weiss, a resident of Montpelier. Thank you for taking comments on this draft one, and thank you for including the charge from the legislature in the report. And I'm viewing these comments from my experience sitting in on legislative committees. The report needs to make a compelling case for each of its recommendations. And I find, unfortunately, the report to be less than compelling regarding many of the recommendations. I have 6 points to make today. The first one, and these are kind of in the order they come in the report. There's an alleged inconsistency between districts that has never been documented. There are lots of claims that districts handle things inconsistently from one another. I've heard the claim many times and have never heard anyone provide specific examples. Thus, I don't find any basis for recommendations to improve training based on these alleged inconsistencies. I suggest that the report describe the training that is already being provided to district commissions and coordinators, why that training is sufficient, because I haven't heard you rebut that the training isn't sufficient. And state in the report that the board finds that inconsistency has never been demonstrated and that the board sees no need to alter its existing training patterns. And this will challenge those making the unasserted claims to provide specifics or stop making the claims. My second point is relating to the retaining appeals of A&R permits at the port. The stakeholders did discuss, and I need to acknowledge that I am also a stakeholder in this process. The draft doesn't mention the alternatives that the stakeholders discussed or their views concerning those alternatives. I'm thinking, I mean, somewhat reading the report, and from my experience with legislators, it's present the alternatives, and then why did we not choose those alternatives, and why did we, I shouldn't use the word we, why did you choose the alternative that you're recommending? To make it, as I said, to make it a more compelling case. And the third item, and so my recommendation would be more, that the report would be more compelling and had a description of the alternatives considered by the stakeholders, their opinions, and the reasons why they were not recommended. My third point is the proposed board model. Again, the report is going to the legislature. Likely they'll have questions about why was this particular model chosen, and again, what alternatives were considered, what were some of the thoughts on the alternatives, and why was this model picked in favor of all of the other alternatives. Next item is the court versus the board debate. Fortunately, I don't find that the section makes a compelling case for transferring appeals to the board. Rather, it seems to make the case that either way is acceptable, retaining them with the board or sending them to the board, and that maybe the board is a better choice. And I explain that because the section on retaining appeals with the board doesn't mention any disadvantages to retaining them with the board, at least not that I found, or not that were clearly understandable. Rather, so I suggest that disadvantages to the court model we discussed in the report. If there are no disadvantages, then why is the recommendation to remove the authority of the court to hear the Act 50 appeals? Because the report later does talk about disadvantages. It talks about pros and cons, not to use the terms from the report. It talks about some cons with transferring it to the board, the startup costs and some of the uncertainties and those things. So, and some of the text seems to cast doubt on the wisdom of the recommendation to transfer appeals to the board. I think that's a comment that maybe Alex made at Monday's meeting. Although not using those words. And the report makes unsupported claims that hearings at the board would be more accessible, more user-friendly, more flexible, and more streamlined reports. And we would have needed, I would have needed a copy of the proposed procedures in order to evaluate those claims friendlier, more accessible, and so on. So that part would be, please get those procedures out soon.
I'm working on it. As you know,
I know.
the minutia
I know
of
you talked
that.
about it, and I know there was discussion at Monday's meeting about if
Trying to
doing
get
red
it
line
out.
version or not, some other things about that. So I understand there's more coming.
And there's,
So anyway, I suggest providing more details to make a compelling case for transfer to the board before the legislature, so that they can understand it. Otherwise, the conclusion might be to leave the appeals with the courts. Two more, board capacity and timing considerations. This section is really short. I would think, again, compelling. These are all of the things that Act 181 requires the board to do. List them all out. And these are some of the dates when they're due. And if you have the time and the ability, if I were doing it, I would make a chart that would list each of the items that you need to do and each of the board members. And then over this way, as you're looking at the chart, time periods. How much time would each person be spending in order to effectively complete that, to include 5 board members, the Act 181 staff attorney, staff lawyer, I don't remember which term exactly used. And I know that's a lot of work and maybe beyond capabilities, but at least list all of the items out that you're working on.
I'm sorry, I was trying to follow what you're saying. So you're not talking about like in an individual case if we're
So I'm
gonna.
talking about for appeal.
Okay,
Under appeal,
Oh,
it would list your 5 names, it would list the position of the staff attorney, it would list other staff members who might be supporting the appeals process. And then how much time do you expect each of them to spend on it between now and whenever appeals start being taken by the board? And the same thing with tier 3. Alex would, all your 5 names, Alex would have the most time on it. And I know that's a lot of work.
We have some of that in a master document. and,
Okay, but
Yeah.
maybe make that available just as best you can in the report so that the legislators can see that. Because you're making a claim. My concern is that 3 years out for taking on the limited appeals that you're planning to start with is a really long time in terms of getting things moving. I'm not saying it's not necessary, but I haven't seen a compelling argument as to why it's necessary. And if it's that long, my concern is that the legislature will say, well, if we can do it with the courts for 3 years, why can't we just do it forever with the courts? So make that compelling argument that it's going to take this long, or maybe it shows that it's not going to take this long. I think, Janet, you said that there's a spectrum on that at the moment being discussed. You haven't come to conclusion.
Yeah.
But, and my final point is on prioritizing and expediting housing appeals. Purpose of tier 1A and 1B is to get Act 250 out of the picture in those areas. Board has almost no jurisdiction over housing anymore. So why would the board be recommending that housing appeals over which the board has almost no jurisdiction should be heard by the board? And so consider that question and again, make a compelling argument as to why, even though Act 250 has no more jurisdiction over housing, except in large numbers in the smaller communities in Tier B. So,
Will you provide those written to?
yes, I have them written out, I do plan. I've got lots more comments that are more specific language things in different parts, but I do also remember Brooke had said she's trying to work now on a big picture item rather than typos and grammatical things.
right,
So these are the 6 points that I think would help the process get through the legislature by making the arguments more compelling.
Yeah.
As to what you're doing. So thank you for taking the time to listen to my comments. And I hope you find that they have merit and help you shape the report in a way that will get it through the legislature more easily.
Thank you, Thomas.
Yeah, it's really helpful, Thomas, to have that perspective. And I do appreciate all the time and effort, not just on the appeals study, but that you have spent with us at the LERB, our meetings. Your feedback is really terrific. I appreciate it very much.
Thank you. Or you're welcome. I guess that's the correct word.
Zachary,
Yeah. Hi, everyone. Can you hear me okay?
yes,
Okay, great. Good afternoon. For the record, my name is Zach Handelman, and I'm an attorney at SPNF Attorneys, formerly Stitzel, Page, and Fletcher. My firm represents municipalities across the state and participates in a large number of municipal zoning appeals to the Environmental Division. And I think many, if not all of you, know my colleague Dave Rue, who had a conflict today and couldn't be here, but he does intend to weigh in with written comments at some point. And then for the record, my comments are my personal comments and don't reflect the firm's or our clients. And also, I just found out about this public comment period this afternoon and only quickly have read through the report. So apologies for not having a more cohesive presentation for you all. And I guess I should also mention that prior to joining the firm, I did clerk for 2 years with the Environmental Division. So I have some familiarity with the existing appeals process. And then,
Correct?
yeah,
We
I
may
just
have
wanted to walk.
you,
Oh, sorry, go ahead.
I said terrific. We may have to ask you some questions.
Yeah, happy to answer any questions. But I did have some practical comments that I wanted to maybe walk through that I jotted down as I worked through the report, if that would be helpful.
Absolutely. Did you want me to put the report up on the screen or anything?
If you want, I have it up on my other monitor here. So whatever is helpful for you all for referencing sections.
Go
But I
ahead,
can
Zach,
see
we're
it
pretty
myself.
familiar with it.
Okay, so looking at the proposed board model, starting in section 8, it looks like you're recommending supplemental record review for almost all types of appeals, Act 250 and municipal. And my comments are mostly focused on the municipal side, recognizing what you've all discussed about, there's not a present recommendation to transfer municipal appeals immediately, and that this is only a first draft of the report. But I did want to flag a few things that jumped out to me. Subsection A3 talks about audio recordings of any hearing as sufficient for the record. I'm assuming this is in response to probably the many comments you all got about transcription services for municipal hearings and the delay that those transcription services are causing in the process. Just to emphasize that right now it's taking about minimum of 60 days, more like 90 days to get any type of transcription of a municipal hearing. We only are aware of one transcriber who will do those municipal hearings. So that's how I understand this, what this subsection is intending to address. If not, feel free to correct me, but I do think there's a practical limitation with having audio recordings only for the record, unless requested and paid for by the parties. I think if you're going to be using an audio record, what would that actually look like if you have a hearing that goes over multiple sessions and involves several hours of testimony? When you do get the appeal, what would the legal briefs actually cite to? And would all of the board members be listening to that entire recording? So if it's not uncommon to have, more than 10 hours of hearing on an application, and to listen, once you have an appeal, you would have the applicant listening, you would have the appellant listening, and you would have the board all having to listen to those 10 hours and identify whether there's evidence in the record to support the lower board's findings. I just think that might be a challenge to only rely on the audio recording rather than having a transcript that you can search for that may have an index. So I just wanted to flag that as a practical difficulty and continue to emphasize that municipal transcription services are difficult to find and are delaying the process.
Really
I
important.
also, actually
you for letting-
subsection 2 right above that. Sorry, did I cut someone off?
No, go ahead.
Okay, subsection 2
Yeah,
above that
I-
mentions all recorded materials, and then lists local board, district commission, district coordinator, or A&R. My understanding is that this report is not recommending transferring A&R appeals to the board or making them on the record. So you might want to consider taking out A&R in that subsection. That might have just been an oversight.
Jeffrey, where are you in the report?
Section 8A, subsection 2 on page 17.
Oh, yeah, I see, I put in A&R. Okay, gotcha, thank you for catching that.
Okay, and then I wanted to talk a little bit more generally about municipal zoning appeals and the report's recommendation that tier 1A and 1B appeals from municipal zoning boards go to the board with supplemental record review or on the record review. So just some questions that I had, and you don't necessarily need to answer them for me now. These are more rhetorical or like public comment. Public comments phrased as questions, but would this be requiring municipalities in those tiered areas to adopt the Municipal Administrative Procedures Act and convert to on the record review? And would they have a choice whether or not to do so?
Simple answer, no.
Okay, so,
Those that already have on the record review would be on the record. Everybody else would be just supplemental.
okay, so I guess maybe this might be my lack of knowledge on how supplemental on the record review works, but my understanding was that it was still, the record is still being created by the municipal board, and there's opportunities to supplement the record on appeal, but ultimately you as the land use review board would be looking at whether you're still deferring to the lower board's decision and looking at whether there's substantial evidence in the record to uphold their findings of fact. So to me, it still relies on a complete record below and the taking of evidence and compliance with certain administrative procedures. So without requiring MAPPA, I'm not entirely sure how you could do supplemental on the record review. You would need to ensure that municipalities in those areas are sophisticated enough in developing a record that's will support their decision on appeal. So that's just something I wanted to flag. And also to
So-
emphasize that, oh, go ahead.
It's not completely clear, but you're suggesting that this supplemental record review is something we made up. It's not like on the record review. It's something that we're considering and we gave it a name to. And it is not to suggest that municipalities would need to meet the APA requirements for on the record review.
Okay, that's
So
helpful. And
it's
Oh.
sort of a hybrid model that we thought we could use to give some deference to a lower panel's decision. We would take the record that was used for that panel's decision, and we would consider that record, and we would consider supplementing that record where there was good cause to do so. Maybe part of that good cause could be, we see that the record that they used was insufficient. And we would want to see more record. Maybe it's that a neighbor felt that, they didn't have time to provide certain information and that we would see it as relevant. And so it's something that we will have to, better describe in time and probably do guidance or rulemaking on. But it's not to suggest that municipalities should pursue on the record review.
And let me jump for a minute, Zach, because this is Brooke. All right, so, because this is really important what you're bringing up. So if a municipal permit or municipal application is filed and it is the same project that is going through Act 250, we are suggesting that the zoning case applicant can elect to come over to the board for consolidation with the Act 250 case, so hopefully there's only one hearing. Now, the dilemma that presented was, we're going to allow that transfer because for consolidation. Some of them might come from on the record towns, some of them might come from de novo towns. And so if we're going to allow that, do we maintain on the record and de novo based on what their current status is? And so here's the reason why we chose supplemental for those particular cases that are being consolidated. Because if you're consolidating them for a hearing and you're taking evidence, how could the municipal case, why should it be on the record if you're taking other evidence anyway for the Act 250 side? So that's why we were trying to struggle with what is the best kind of appellate review if we're wanting to consolidate these. Do you have any insights into when cases were consolidated? And I know it happened infrequently and still does it to the court, but was the zoning case, even though it was tried with the Act 250 case, was it not tried because you can't take any evidence on the record appeal for that municipality?
So a few things there. I guess I'll address your question first. I'm not aware of any coordination of an Act 250 appeal with an on the record municipal appeal. If there were, the court would likely, well, I can't speak for the court, but there would be a briefing schedule for the on the record municipal appeal. There wouldn't be any new evidence under the current standard for on the record review. And that would go forward with briefing, and then the court would have to schedule a trial for de novo review over the Act 250 permit. So I don't think those could be coordinated currently, and I don't see how, well, let me address this issue that I identified, which was you're talking about coordinating or transferring municipal housing appeals or zoning appeals generally. That's unclear if it's just housing or all zoning appeals in tier 1A and 1B areas, and consolidating those with Act 250 appeals. But my understanding is there is no Act 250 appeal, or there is no Act 250 jurisdiction over those tiered areas. So there's really.
Yeah, I hadn't go to that yet.
There is some Act 250 jurisdiction in the tier 1B for non-housing or housing with more than 50 units.
Okay.
Right. But to address what you're talking about now, which is, you know, if we were to take just municipal housing appeals in 1B or all appeals in 1A or whatever, again, what we're dealing with in that circumstance on the tier 1A cases are, and 1B housing, is we don't have jurisdiction anymore. So it's not a consolidation, it's nothing. We're trying to strategize and offer the appeals on housing to speed up those particular types of appeals to come to the board. So we have that same kind of situation where some of those tier 1A municipalities are already maybe on the record. They may not be. And so the question is, if we were going to take those appeals, do we stick with the standard of review of the environmental division? Or do we go to this supplemental record review that recognizes the record below, the information that's already been presented, to avoid duplicating that process and having a hearing again on that information? The new evidence, if there was any that should be in the record, that's the only thing we would be giving the hearing on. Not going to go back over and have the same witnesses come and testify again. That's at least the notion in order to shorten this process. So I just wanted to try to explain, you know, this was complicated because it's like we're dealing with different standards of review, and we're trying to figure out, do we keep with those? What are the challenges or the objections to those? On the record is objected to by a lot of people because it requires the participants to often lawyer up or hire experts right from the get-go. And, you know, there is a small number of appeals that are actually filed versus the number of cases that are processed by municipalities. And the question becomes, are we able to move those quicker through the system, still giving due process? And if so, how? Because, you know, on the record is challenging for neighbors to find out about something and, oh, there's a hearing this week, I have to go to it. They have no opportunity to prepare for it. But by the same token, many developers, particularly small developers, don't want to spend all the monies that they normally have to in a contested case right up front. So we're trying to balance so many different interests. De novo appeal, well, yeah, that's criticized because, oh boy, we have to start all over and pay our people to come and go put on the dog and pony show yet again. So yeah, this is really challenging. But what I'm hearing from really interesting information. What do you think about the on-the-record towns? And you've had some experience with that at the court. On the record goes a lot quicker than de novo, doesn't it?
Well,
I mean,
not currently. Currently, it's a 3-month waiting process just to get a transcript. And there's a number of transcript requests, pending right now where nothing is happening in those court cases. And the judge has had to authorize continuances because the town and parties are just waiting on transcripts. Once you have that transcript, you're already at least 90 days in, then you have a briefing schedule, which involves, typically 30 days from once the transcript gets in, you would have the appellant file their principal brief, and then 30 days for the applicant to respond in their brief, and then potentially reply briefs, and then the court would have to review, take that case under advisement and review the entire record. So I can't speak to whether they're currently faster or slower than de novo appeals. I'd rather speak, I think, to your comment about the difficulty in the different standards of review and the potential that I think what you're suggesting is that towns can stay the way they are. They can elect whether they want to be de novo or on the record. But then once that appeal comes in, you're talking about letting maybe the applicant decide whether they want to go to the environmental division or the land use review board. And then if it's in the environmental division, is that de novo? If it's with the board, is that supplemental on the record? And I think the practical limitation is the board, the municipal board has to develop a record. And in a de novo appeals process, you have lay people on these boards, sometimes some with more experience and sophistication than others. But you'll see a wide range of decisions coming from municipal boards across the state. Some where they just ignore half the criteria, others which address everything and issue 40-page decisions and for de novo review. But once you put the obligation on the municipality to develop a thorough record, then the applicant comes in with experts and has to develop that record for them to preserve their application for the appeal, and the appellants would have to do the same thing. And when you start opening up the record in that appeal for under a just cause standard, it's unclear what just cause would be. I think that it would open up a lot of debate in the appeal and would take time to settle what should be supplemented, what should be allowed. It would create potentially some confusion and I guess, yeah, the biggest issue is how is the municipality developing the record below? If it's de novo, they're not going to be taking evidence or swearing in witnesses. And it would create different burdens on the parties, and I think just create confusion, and it's already creating confusion. It sounds like I'm confused myself. So I just wanted to point this out. And I know you're all thinking about it a lot, and I've kind of lost my train of thought at this point because now my head's spinning. Yeah.
We were thinking of this as maybe a time-saving thing, and depending on situation, it might not be. So, yeah, we'll think about it further.
Jack, did you have some additional comments that you were trying to work through? If so, I'd love to hear them.
Yes, couple more things just to touch on quickly. I don't know if I didn't see this anywhere in the report, but I feel like I remember I sat in on a couple of the stakeholder meetings just to listen in. And I thought someone brought up, there's this fairly recent Vermont Supreme Court case, Rainy Dairy Farm, major subdivision appeal, which is a major development in zoning law that I think really needs to be discussed if there's going to be a recommendation that municipal zoning appeals get transferred to a board. And if you're changing the standards of review in those appeals, this case, the Supreme Court explained that the Environmental Division has jurisdiction over certain private property rights that arise out of an appeal, such as the determination of whether an easement or right of way exists to access development. And this is a major implication for municipal law, because for existing towns that are on the record, and in general, the municipality makes determinations in the first instance. And the legal determination of private property rights, my understanding is that private property rights should be adjudicated by a court and not by a quasi judicial board. These are complicated analyses of law and fact, and if the report is recommending making towns or making the standard of review on the record or supplemental on the record, that means towns have to take evidence and make legal determinations that I'm not sure whether they can make or not. And I just want to flag that as something that I think really needs to be part of this conversation when it comes to zoning appeals. So I'm curious if you have all discussed it at all, or whether this is the first time someone's bringing it up, but I wanted to flag that.
Jack, can I ask you to clarify a little bit? So you're suggesting that the Supreme Court's decision sort of throws a wrench into the way that we've been thinking about development review of private property, basically, in this state. And that we give lay panels the authority to do that. And you're suggesting that this Supreme Court, at least on the lower panel, it's lay panels, even at the municipal level, but also with Act 250. You're suggesting that the Supreme Court decision sort of throws a wrench into that thinking.
Yeah, I think the Supreme Court decision addressed the environmental division's jurisdiction, and that was it. And if you take that to the next logical step, which is that towns have to do, municipalities have to do everything in the first instance for an appellate body to have jurisdiction over that issue, that means putting legal determinations in the hands of the municipal boards. That's not as big of an issue in a de novo standard of review, because the court can take the evidence anew and make that determination for itself, and you have a court adjudicating private property rights. I'm not sure, and this hasn't played out, and this isn't a problem. Well, it may turn out to be a problem in those on the record towns. I don't know if there's any case that's actually addressed this yet since Rainy Dairy came out, but how would the appellate body defer to that lay board on a legal determination of private property rights? And is that constitutional? I don't know. I can't provide that insight, but it's something that I think needs to be discussed, especially potentially moving to a board model. I think that's something that needs to be considered.
Yeah, Zach, could you shoot me a copy of that decision? And because I'm curious, so you're talking about the fact that the environmental division's jurisdiction has been expanded to be able to adjudicate property rights that used to be in the civil division of the Superior Court? Or
Yes.
Okay, okay. We did talk about that, but only in the context of Liam Murphy's proposed court model, which was to expand further the jurisdiction of the environmental division and not for the board to take any appeals. So that's the only time that we discussed that particular expansion jurisdiction. So
Okay.
yeah, please, if you would be so kind to send me a copy of that, because I'd like to read it, now that you've raised this with regard to, the appeals. That would be very helpful. I would appreciate
Yeah,
it.
absolutely. I can do that.
Keep going, or, we have one more question.
Sorry.
Do you have
Um, I'll run through the rest of my comments real quick. So there's a lot of comments throughout the report about expertise, both with the court and the board. When it comes to expertise, you know, I don't doubt the board's experience and expertise, but when you're talking about on the record review, you're deferring to the municipal panel below. So I feel like there's an inherent conflict between the standard of review that this report is recommending and the suggestion that there's potential, you know, one of the benefits of moving to the board model is more diverse background and experience. I think, does that make sense? The tension between deferring to the lower panel and also recommending that the board has more experience. And I don't mean to call into question any of your experience. It's just something that stood out to me.
Yeah. Yeah, it's like a very good kind of inconsistency of, I mean, all you're doing is reviewing the determination below from a legal perspective. So I get your point. It's a very interesting point. Thank you.
Yeah.
You did right.
And then I guess lastly, I'll just end with, there's a lot of discussion about housing appeals, and I think that term absolutely needs to be defined. What is a housing appeal? Is it single family, multifamily, priority housing, accessory dwelling unit, seasonal camps? I mean, there's so many types of permits and that might touch on housing, administrative permits versus conditional use permits. And again, I'm more focused on the municipal side, but if you're going to be talking about housing appeals throughout the report, I would recommend defining that term.
Gotcha.
I think that
Did you
covers
ever-
everything.
Oh, sorry.
Everything? Okay.
Thanks, Zach.
Thank you so much, Zach. We look forward to hearing from you further, and David. So,
And Catherine, you had your hand up.
I did, thank you. I can't get the raise hand command to work. I'd just like to thank Zach for bringing up that court case. We're a little concerned about the implications of that on our communities and talked about it quite a bit. So I do think it's a good point to bring up. I just had a couple of minor points I wanted to share. I'm Catherine Dimitrick, and I am a member of the stakeholder group. I sent Brooke this comment earlier today, but I just wanted to note that I think somewhere in the report, it's important to note that the stakeholders' job was to provide feedback and input to the land use review board as part of your decision-making process, but that the recommendations belong to the land use review board, did not come from a stakeholder consensus. That being said, I thought the report was actually quite well done. As a layperson and not an attorney, I appreciated the readability of it from someone who's not an attorney. I think that it was very understandable in terms of the recommendations that are being made. And since many of the people you're delivering this report to are not attorneys as well, I think that it serves its point very well in making it very readable and approachable. The one particular policy comment I wanted to offer for your consideration is in the recommendations for municipal permit appeals, you focused on the Tier 1A and Tier 1B areas, but somewhat related to Annette's comment earlier, I think it would be worth considering expanding that to centers, village areas, planned growth areas in the regional plans. And that is to expand that opportunity to more than just some of our more built up areas. For example, in Lamoille County, there's only one municipality that's even eligible for Tier 1B. And so you're really limiting the scope of where that could apply by only limiting it to Tier 1B areas. The other thing that does is if the point of moving those appeals to the land use review board is for some speed and relief to housing projects, communities that don't opt in to Tier 1B because they want to keep barriers in the way of housing don't get the opportunity. Those projects get one more barrier by not having that speedier appeal process. So just wanted to throw that out there for your consideration. And then I have to jump to another meeting, but I appreciate the opportunity to comment. Thanks.
Thank you.
thanks so much. Appreciate it. Annette?
So on Zachary's comment about the supplemental record, it's always interesting to hear a lawyer's perspective as a non-lawyer. So I didn't want to use the term on the record because that means something to lawyers. And now I'm wondering if we need to get rid of the word record altogether. The idea is not that everybody's going to do more and lawyer up more at the municipal level or the lower level. The idea is you're just not going to throw out what happened at the lower level. So I don't know how you can name that differently, but maybe the word record is a problem. He's raising a good point, but you see the wheels turning and how a lawyer reviews or would look at, oh, well, if we're going to have a record review up above, then we have to do more down below. And that's not how I view this. I view this as whatever happens down below, the court gets the benefit of, and then that can be supplemented.
Yeah, I think that's an important point. Now, I know that there is a need to package up documents or scan them and email them to the higher tribunal for appeal. But we're not asking for de novo towns to become on the record towns. I think this point that you're making is really important. The other issue about the transcription of hearings and that, I think that we need to be willing to look at other possibilities like AI. And if people want to, take the recording, and I think Zach's points are really important and I really have to think about them. Because when you're trying to point out, oh, there's really important testimony below, so-and-so said this, it is important. I mean, what are you going to do? You have to be able to describe that or quote it or whatever. So I think there is a need to recognize and embrace technology on this. If somebody, if a recording is, you get transcriptions on YouTube, are they always accurate? No. But I would think that if you want to extricate testimony from such a transcription, not an official transcript, and want to put it into evidence and identify it by the location it is on the tape recording, then it's easily verifiable. And if someone is trying to use something that is not recognized and there's a word that's awry, certainly that kind of information could be verified fairly easily, and especially if you have someone on the other side of the contested case who will call you out if you're saying that the transcription said something that it didn't. So I think that that's an important ability to remove the impediment. I don't know if John Groveman has any thoughts about this, because he has more experience with, utilizing records or considering these other less formal legal requirements. And that makes a good point. It's that we don't want to throw out the work below, but we're not trying to make that an on-the-record appeal. We're trying to be more flexible and allow the system to be more accessible to people than the court systems.
Yeah, I mean, I did want to, if it's okay, just to follow up on just a couple of things. I agree with you. I think that technology, there are different ways to create a record. I agree with Annette. I think that, to Zach's point, I don't think that the idea, there's plenty of reason for plenty of opportunity for the board to use its expertise, even if you have this process where you are really utilizing what happened below, but you could supplement it. But because the board gets to make that decision, I really liked what Chair Hurley said about saying if you felt there was a gap in the record or the information wasn't there. Those are things that courts are just not as good at, because they just want to know, are we just reviewing the whole record or are we doing it just all de novo? I think that's a good example of where the board should use its expertise. And also with Act 250 in particular, being able to review the conclusions of the legal issues are really important. I mean, it's not just, you're not just stamping what a district commission did on the law. I mean, right now, there are appeals with the boards of party with their own questions about a decision that the commission made on the law, and that creates precedent for Act 250, for the criteria for the law. So putting aside the supplementing of the record, which, you know, I agree with what Annette said, there's still a lot of reason to have the board overseeing the legal aspects of Act 250 decisions to really, as you know, Ron Shem said, and it's in the record of all the meetings, it kind of puts the board at the top of the pyramid, really overseeing the program completely through training of the commissions, providing, you know, the commissions with what they need to operate, through rule changes and guidance and procedural rules, but also through decisions as they come up in real time, and to make those decisions legally through Act 250, whether the record needs to be supplemented significantly or it doesn't. You know, I think that there's a real role there. And the only other thing I would say is I need to read more carefully this decision on property disputes and jurisdiction. I did read it, but it's been a while. But you know, when I hear this come up, I just don't think that, first of all, I mean, I don't go back to the data comment. I'd like to know how often like property disputes are resolved in permit cases, how prevalent is that? But also, that shouldn't drive what's the best system for making permit decisions and having a robust Act 250 program. You know, I just don't think that should be, you know, we've existed for hundreds of years going to the court to deal with property disputes about, you know, where's the property line? Does someone have an easement? You know, so on and so forth. I just don't think that that should be the driver of the system that we created. I think that's where we get into trouble. We create around a system around a kind of a narrow legal issue of like property rights versus what's the best regulatory system, you know, and what's best for the program.
Kirsten, you were gonna ask a question at some point before Zach finished.
Yeah, I mean, something else that just comes to mind that maybe I'll just kind of throw back at John, but it could be too that there's some recommended legislative change because of this kind of property dispute jurisdiction wrench that's now, you know, in play. Maybe. So, you know, that's just also a possibility, right? But I did want to ask Zachary, if I may, Zachary, are you still there?
Yeah, I'm still here.
Yeah, so I hope you don't mind. I'm gonna hopefully draw on your experience when you were working at the court, the environmental court, and thinking about the equity issue that, I don't know if you were here at the very, very beginning of today's meeting, but there's been some robust feedback that was received during the public meetings on Tier 3, raising concerns about equity between rural and urban areas, and you know, more potentially like pro se participants at the court. So I'm just wondering, I know, you know, we've got some recommendations in the draft report concerning having an ombudsperson. And in my mind, like, that's great. That's whether it's to assist an applicant or any participant through, you know, an application process or sorting out what they may need to do, or understanding what an appeal process, you know, involves. But I'm just wondering, you know, it only gets you so far, in my mind, whether, you know, whether an ombudsperson is assisting someone with their applications. At the end of the day, they may need a whole range of consultants to do a wetland delineation or draw up a site plan. Or if they're at the court, maybe they reach a point where they also could need to hire an expert or an attorney. I'm just wondering, in your experience at the court, are there any specific tools that you think could be really effective to put into the system that would really help those more typically pro se participants, who in many cases wouldn't be able to afford an attorney? And so they're, you know, making their way through a process that they probably don't understand very well and learning as they go? Are there any tools, and I know I'm asking a lawyer, right? Probably you're thinking, oh, hire a lawyer, but from the court side of things. And I know there's Vermont Legal Aid and there are some things out there, but my experience is someone who's worked on the administrative side of land use. When I would refer people to seek out these public resources, it didn't materialize into anything. And they simply wasn't anything available for that need. And I'm just wondering what you might say, like is there something particular, like if you could just sort of, wave a magic wand or think about how to make that better for those folks.
Yeah, I think that's an important question and consideration for all of you. I think the problem that you flagged is, prevails the entire judicial system and administrative appeals process and the legal profession in general. It's complex and difficult to navigate, and I don't have one wish that I think would make that process simpler and easier for anybody to navigate by themselves. I have observed pro se applicants attempt to navigate the appeals process on their own. I've also observed them represent themselves in front of the municipal panel below. And I think what you see is a definitely challenge. There are a lot of challenges that I could name in when you have that happening, especially for a pro se developer. Oftentimes where you'll see people start to represent themselves, I think, is when you have something that's an administrative permit, so permitted by right, like single family housing. But even then, you might be hiring experts and engineers, and it's just development in general is costly. So I don't know if I see the appeals process in the court as being the sole problem with access to justice in the development process. I think there's a lot of different levels, and the court isn't the last level in that appeals process. There's also the Supreme Court. And so I don't know the rules of off the top of my head for the Supreme Court. I don't think you have to be a lawyer. I think you can definitely still represent yourself and appeal to the Supreme Court. But if you're making it all the way up there by yourself, you've invested a lot of time and a lot of energy to try and learn the law and the process, and not everyone can do that. And the Environmental Division has a pro se legal clinic offered through Vermont Law School. That's one service where the judges will often direct a pro se litigant to that resource. It's free. You can set a time to meet with a land use attorney to just talk about what some of the process looks like, how to file your notice of appeal, or what a statement of questions looks like, that sort of thing. But again, it's not perfect. They don't provide you legal advice. Same thing, and I'm not aware of any resources below available for people applying before municipal board. So sorry, I don't have a great answer to that question.
So I didn't think you would. I'd ask it anyway. So thank you, Zachary.
Yeah.
Not that I don't think you gave a good answer. It's just I couldn't picture what that might be.
There's only one Annette Smith in Vermont, unfortunately.
There are other people with the name.
There may be more than one Annette Smith.
Oh, I know another.
Well,
So, I don't think we have any more hands up. I don't know, this is a public hearing. I don't know if the board wants to discuss any of this before we adjourn today as a board.
I would appreciate it because I think there's an awful lot
Yeah.
to think about here, and Thomas is right about making the compelling case. Part of the absence of that is we're feeling our way through this and trying to figure this out as we go along. So, I thought his comments were wonderful, but I think that to me really reminded me, okay, we need to get clarity on what we want to propose. And, if the board is not all of one mind on the whole thing or a particular issue or one of our recommendations, we should articulate that, some of us feel this way, some of us feel that way, which that's been the whole issue and the problem all along for the prior studies is that there's compelling arguments on both sides. And there are disadvantages of both programs, and I'm happy to further develop that, but I think knowing where we're going is essential right now for the next 3 weeks of writing this recording, getting it out on time. And we do have some meetings ahead, but what about the idea of this tier 1A, tier 1B housing? Why not just take all housing if the proposal is to take housing? That is a more attractive bright line.
So our first proposal though is to take Act 250, right?
Right, yeah, I'm skipping past that. Sorry.
And so those can be housing projects outside of those tier 1A areas. So, so I don't think we're not taking housing by not going outside of the tier 1A and B areas.
I think we as a board discussed what level of housing to take,
Right.
right? And perhaps the 1 unit here, 1 unit there is not a worthwhile endeavor. And I think that the
Or
focus,
maybe not worthwhile, but not appropriate for this board.
correct, it
Yeah.
doesn't necessarily move the needle substantially
Right.
in housing. So in terms of effort in versus moving the needle in housing, the cost benefit ratio, it did seem like an efficient use of resources. I think the idea of taking on tier 1A and 1B areas specifically is these are the areas that we are all doing the land use planning to try and move the needle and invigorate housing within these areas. And I think the other thing about that too is these are areas that are subjecting themselves to a higher level of review by this board. So to become a tier 1A community, you have to invest in application for this board and prove that you're worthy of meeting the criteria. And so they have held themselves to a higher standard. And so it would be hopeful that on the other side of things, any appeals within those areas, their regulations that we're be reviewing the appeals under have met that higher standard. So that could hopefully be something that we could dispense with fairly quickly and efficiently with minimal resources. So again, that resource benefit ratio is, we're doing a lot of front loading with these areas in terms of ensuring these are the correct future land use areas. They have a higher level of review and standards. And these are the areas that we're anticipating the most housing out of. So I think that was in order to, I think to take Thomas's point and make a stronger argument, I think that would be helpful making a stronger argument. But I think what I'd like to sort of put forward to you is I think there's a balance. I think Catherine Dimitrik and Thomas both suggested sort of two ends of the spectrum where Catherine complimented you with readability and is a very readable report to the average layperson. I think Thomas was saying that you could add more to it. And that's the drafter's dilemma, is how do you create something that creates a good point in a fairly succinct area. So as you head back into drafting, I think my guidance to you is don't go overly long or technical in trying to make your points. I think you've hit the mark. You have some good feedback on that. And, I think that it is a reflection of where the board is at. Hopefully, this will help things in your direction.
Alex, Kirsten.
I'd love to talk about Catherine's suggestion. It was short and substantive. Her suggestion was that we consider, taking municipal appeals not only within tier 1A and 1B areas, but in the future land use areas that are eligible for tier 1 status, even if they don't have the tier 1 status yet. And her point was that there are many rural communities that will not be eligible for tier 1B or 1A, but will still have future land use areas designated for appropriate denser development, whether it's a village area or what have you. So I'm curious what other board members think about expanding the recommendation for taking appeals for municipal housing applications within those
For
future
future
land
land
use
use
areas.
that are
I
eligible.
thought we were already doing that. Because I think what we were saying is we'd be taking on Act 250 appeals in those municipal areas that wanted to consolidate.
So I want to leave the consolidation issue aside. Let's forget about that for now. Like, yes, we're gonna allow people to, but I'm talking about municipal appeals that don't have an Act 250 correlate.
Application, yeah.
Well, I think, again, it is sort of germane to the discussion, because if you're outside of the tier 1A and 1B areas, then you have the potential for Act 250. If you don't have Act 250 involved, then what is the scale of the project? The scale of the project is perhaps fairly small, and it gets again into that resource allocation in terms of. So that's
I hear
my
you.
answer to that.
Okay,
But
that's valid. My concern is that
We could say
equity
multifamily.
issues.
Or, well, hang on a minute, let me give one piece of information. Only talking about 20 appeals a year. In the municipal housing category. Okay, there are 60 municipal appeals per year. 1/3 of them are housing related, even if it's a yurt. Or accessory, but yeah, it has to have a component. And the court, when they give us the statistics, called out a couple of them, but they cast it as wide as possible. So we're only talking about, at least based on history, 20 cases. And what I am more interested in is the bright line. I have a housing case. We're getting under that board. Not, I have a housing case. Well, wait a minute. Am I in a potential downtown development area? You know, it's not tier 1, whatever. I'm looking for clarity. Tier 1A and tier 1B housing was kind of clear. But I do have 2 other emails that also are urging for consideration of either zoning in general or particularly the housing appeals for zoning. And I appreciate do we really want single family homes? But if that's not the majority of they are we better off just taking that
It's also
category?
like a rural equity issue in of itself. Like one individual unit is a unit and would be the type of housing project that would be more typically in a more rural location. So I liked Catherine's suggestion, and I've been on the side of like, let's just take all the housing, the municipal housing, but even the 1 unit projects, that's just, I think we have to be careful when we get into multi-use. You have, a commercial project for 1 housing unit, or, I think we have to define. So that's where I'm at.
So you're all housing, you're still like tier 1A, 1B. You're sort of wondering, but maybe all housing because it's not too many to begin with.
I like clear line.
I'm not sure where I'm at. I just want to have a
Yeah, I'm not
conversation.
sure.
Right.
It's that many.
And I think this might get into the check back with us later.
Yeah.
Because we don't know how many appeals there might be in tier 1As and 1Bs. And I think the other thing too is that in terms of economy of scale, it's 20 appeals now, and maybe some of them are single units versus multi units. But we haven't stood up, we still have the interim exemptions, you haven't stood up the new tiers. And the whole idea of this is to invigorate housing, to have more housing. And so you can only guess that there might be more appeals of certain types with more housing, particularly where there's more density and there are neighbor concerns and what have you. So I think, I hate to use the term, but the biggest bang for the buck is I think where we need to be honing in, being careful of where our resources are. I think that's another area that I heard tonight that was brought up is in terms of what can you do with the resources that you have? And sort of that challenge is, I think the biggest bang for our buck is not anything to do with the appeals process. I think it is that ombudsperson that you detailed. And then I think we can hone in on areas that can effectuate the more units at a time and perhaps revisit that too, as we continue on. And one would hope that there would be less appeals over time and not more as we continue to improve upon the Act 250 process as well. So I like the idea of
These less Act 250 appeals.
checking back in.
I am really concerned though about what Kirsten has identified being the equity issue because I hear everything that you guys are saying, but for teeny little municipalities, 5 units may be, you know, like when we were doing the Rutland Regional Plan and yes, I was like, now wait a minute, is there equity here? And it's like, well, we have so much infrastructure in Rutland City that we're able to, you know, assign, you know,
The whole housing
unit,
target.
right?
Yeah.
And so, but for a small little community, a couple units might be a big deal for them. And I don't want to lose that just because we're like, oh, you're not big enough to worry about. I think we do need.
But, I mean, what difference is there for one of those cases between the court and us? Are we really gonna be that much quicker that it creates an equity issue that isn't already?
Well,
Good question, because I'm sorry, I don't mean to interrupt you. I want to say, I think ultimately that's the determination, or at least part of the analysis that we need to make. Because for me, I don't know that we can deliver a faster system that is more efficient,
Right.
that is on equal footing with the work product that's coming out of the court. That, I think, is the answer. I have not decided on this at all. I have been debating back and forth because to me, I feel like I need to be able to demonstrate to Vermonters that we have devised a system that can produce what we're saying, what they are looking for an answer here to help cure the problems and the delays, to help cure the housing crisis. And if we can't feel confident that we not only can provide a better system more quickly to alleviate all of those goals and concerns that we talked about with the stakeholders, then why would we do it? And that's when the cost benefit analysis also comes into it. At what cost? Can we demonstrate an improvement? And if so, at what cost? And that's where the rubber hits the road to say, we think this is a good idea. Here's how much it's going to cost. We recommend you do it. It could be, here's what it's going to cost, and we're only going to handle a handful of cases, and we think it's too expensive. I mean, there are different recommendations and decisions that need to be made here. And for me, this is vitally important, and the resource issue and whether or not we can figure out all these moving parts that many of them we have no information about, to say, you know what, this is resources we need, please set this aside, we'll build the infrastructure, we'll do the Act 250 permitting, then we'll check in with you and we'll see what else we can take during that process. But we have to know that what we've created is going to be successful, and we must ask for the resources to make that happen. Or know that we have them, at least based on what we're predicting.
I think another way to address the issue that you brought up, Kirsten, is to take a look, and you've done a phenomenal job of working through the data that we have. But in this, and so I'm not sure that this is going to be reflective of the data. And again, you're looking at such a small number, right? But for the truly rural towns that do not have subdivision and zoning regulations, Act 250 is the permanent process. And so by way of us taking on Act 250 appeals, I think we are providing or addressing some of that rural equity issue.
Some of it.
Yeah.
Yeah.
Some of those, you know, small lot subdivisions or single family homes could be also the same, you know, pro se people handling an appeal. And I think a board model could offer more flexibility and be more user friendly for those, applicants. The thing I just wanted to touch on quickly, smallly, but it's something Sarah just said about the tier 1A, 1B, that it's meant this quote unquote higher. I don't myself completely agree with that, frankly. I think that it's just been planned, right? It's been planned out, the whole area. I mean, taking away Act 250 altogether from those areas, it's like higher compared to what? So I just would hesitate to kind of frame it that way. I think we should be careful with the language.
I got some feedback from a legislator today, in response to how we've sort of talked about this in our tier 2 meetings. And, their feedback was, we worked really hard to make sure that those areas of exemption have adequate, regulations in place. And that means a higher level of, review. So they were concerned
Higher
that
level of review than what? I mean,
than those who don't meet the,
The municipalities that are not, it's not compared to the Act 250 review process. It's compared to the universe of municipal
Yes.
regulations.
yes,
Yeah.
yeah.
I just want to be careful with the language that sort of,
so let me ask you a question. That higher, I mean, so, you know, the zoning ordinances are not being altered necessarily. They just already meet that standard, or maybe they are being amended to meet that standard. And the reason why I ask, because I'm trying to understand exactly what you're saying. Because my experience, 10 and 1 and 10 acre towns, you have to have, your subdivision and zoning has to be up to snuff, whatever that means.
Yeah,
Really. So I just don't it just sounded when you were describing it like they had to do something to their existing ordinances to make them a super ordinance or something like that. And that's not the case. We're just saying they have to be, good, satisfactory, comprehensive subdivision
Yes.
ordinances, right?
right, and there's been this robust planning that's been evaluated.
And I know that there's a massive continuum of, and then no ordinances at all. So I follow what you guys are saying. Perhaps the language might be interpreted negatively or positively. I don't know which way, but I follow what she's saying and I appreciate.
I appreciate your work on this. It's been a lot, and I think, bearing in mind too, that this was supposed to have a due date of February. And you stepped up to the back and said November, and, so I think, given all of the diversity of voices that you have, I think you've done a good job of capturing it so far. And although perhaps it doesn't have the, clarity that I think, to Thomas's point, in terms of emphasis on things, I think you've done a very good job at reflecting the diversity.
So, but I wanna make sure that Brooke, feels that she understands what the board's position is as a body. And, I think that taking Act 250 permit appeals, aside from the housing issue, aside from, efficiency issues, aside from costs, is just important for this program. And this program, as Alex was pointing out last night in the conversation, it has a horrible statewide reputation, whether deserved or not. And that if we were to take control of Act 250 appeals, we would have more ability to control the narrative about this program and to correct what I think all 5 of us probably understand as huge misperceptions about this program. That most applications are dealt with administratively. Most applications get approvals, like by far, all of them almost get approved. Most of them are not appealed, and that the the sort of time frames that it takes to get an Act 250 permit are oftentimes because of A&R permits that have to be waited for before the Act 250 decision can be released. And so I feel like separately from the housing issues and separately from any cost benefit analyses, that is important for us to do. No question for me. And
Same.
yeah. And so secondly, this idea that you just put forth about phasing this in, Brooke, I think is smart, because we do not know what the hell is gonna happen. And, you know, not only are our plates absolutely full, especially through the end of next year, there's no way we can take this on. As you pointed out last week, or this week in our meeting, we also need to do rulemaking or guidance around this. So we need time. And then we need to get data about, you know, this changed rubric and appeals and what it's going to do in terms of appeals. We also need to understand what our capacity is as a program to deal with that. Is there going to be litigation around tier 3? Are there going to be thousands of landowners who are coming at us with pitchforks, you know, because they believe that you're taking their land because you've identified some tier 3 on it? You know, I don't know. We don't know. So I think that a phased approach is a good idea. I think that it makes sense to start with tier 1A and B.
I'm gonna throw this out. I know it's 6 o'clock, but what do you think about the standard of review?
I think that what we were talking about makes sense.
Get rid of the word record.
It may be, I feel like, you know, it's sort of like, I don't think we need to worry about that Supreme Court case. That, I mean, if you, you know, but I sort of feel the same way about this. That's lawyer stuff. We're talking about, a lay panel process that is in law and has been in law for decades, and actually more than decades in terms of zoning. Well, yeah, still decades. Century, yeah. So,
And just to be sure, nobody here is looking for us to take on anything outside of permitting. We are not putting forth our program, as an appeals body to say, oh, and by the way, we'll figure out your
easement. We're not gonna do that. We're not gonna worry about that. And that's for somebody else to worry about. I forgot, what was the question?
Well,
The review, wanted to know whether we.
Oh, yeah,
we
the
felt about
supplemental
the
review.
Supplemental
I think-
versus on the record
I
versus
think
development.
I don't,
This is a
I don't
separate
see-
issue of enhanced.
Maybe if we don't use the word record, I don't care. I think that we're okay with what we have.
Yeah, I agree with you. Tom has some good points, and I think once you maybe have clear direction on the board's position, that will allow you to refine some of it. And I want to let Tom know, and I sort of apologize to Brooke, I keep promising her this schematic of sort of board workload, basically, sort of what you're talking about, but not, I'm sure not as granular as what maybe you had in mind, with like, you know, individual staff and board positions assigned to specific tasks. It's more just like all the tasks. So I keep telling Brooke I'll get it to her, but it will document that piece. I started it and then some of it was a moving target and I was like, oh, so.
And, you know, Thomas, just so you know, I sent a memo to the committees of jurisdiction a month or so ago, asking for extensions on the tier 2 report and the LCAR deadline for submitting the tier 3 rules. And I outlined, here's what we've done. Here's what we still have to do. And it's a lot. And so I made on just, I think, 2 pages. And so they know that there's a lot on our plates. I've heard from some of them saying, we know you have a lot on your plate. You don't have to do it right away. If you want to tell us that you want to take a minutes. So, but
Well, I like the idea of plan to do it on a phased basis. That makes sense to me.
So for the question you asked, I'm still fine with the concept that you've outlined, that we've discussed, where there are different levels of review and we're introducing a new version, which is just basically it's taking what would have been de novo and saying, we are going to grab some of the record, some of the evidence from the lower panel. It's not going to be brand new again. We're going to have some ability to look at what happened below. And I don't think that means we need to create a transcript and turn it into on the record.
Right.
But I think to Zach's point, for communities that are on the record, I think our suggestion is that we would continue to review those on the record. They wouldn't turn into supplemental, right? We would allow that record to be submitted. So I'm comfortable with the way it's sketched out. I like the concept of the supplemental. Yeah, I think if we're, to Kirsten's point and Sarah's, I think if we are going to recommend a stepwise or check-in sort of approach to taking certain types of municipal appeals, then the bright lines you're looking for, I think it makes sense to stick with either the tier 1 line, which is right, or potentially what Catherine's recommending. But to Thomas's point about like, what are the compelling reasons? I think Sarah has the compelling reasons. Her argument is strong on why we would limit it to tier 1A particularly. Tier 1B maybe gets it right on the coattails because we're not doing the same level of review for those as we are for 1A. But I see your argument, Sarah. It's pretty strong. I like Catherine's suggestion. I'm not sure how quite to make the similar strong argument to expand it into all those other areas.
Well, and I think in looking at why Catherine is making the argument is I completely understand. I sympathize with it because I think the bar to get into tier 1 is too high right now.
Yeah, I agree.
And I think our board has some thinking around that, and I think that will help address that barrier to municipalities coming into tier 1. So I think I'd rather tackle that separately. And I think to try and focus and give you bright lines, I think having tiers would be good.
I think phase 1 could be the Catherine Demetric proposal. I mean, it sort of dilutes the compelling argument a little bit, but it's still there. I mean, does it change it that much in terms of volume? I mean,
so
We don't know. Yeah.
yeah,
You don't know because we haven't approved the future land use maps.
Yeah, but also, we're maintaining a tier map. That's under our jurisdiction. We're approving these future land use maps. We haven't talked about them being, I guess it's not jurisdictional. I don't know.
I see what you're saying.
We haven't talked about that, and I don't think we should jump there right now.
Yeah, not to me. You have to get home.
I have been home in days.
All of you, I'm 5 minutes down the road. You can stay over.
We're crashing at Frank's house today. So so it sounds like we're comfortable where these recommendations are as they're spelled out currently in the draft.
I'm good. I have enough information to work through the weekend so that on Monday, I can get you where we're at. There may be further questions and conversation, but this is very helpful. This gives me more clear direction so that I can build the board rules and not scrap them right now. Because I've been trying to articulate this standard that we have created. So I think.
So what, do you think take out the word record?
I think so. I think it's
Supplemental
probably
review,
confusion.
supplemental review, yeah.
I also want to say I'm still falling over this kind of staffing detail. So
Oh, yeah.
that's,
Okay,
you know,
right.
we're, right.
And I have done further discussions with Jenny and Rachel and tried to figure out the best we can from supply side, not knowing much about the demand side. And we do feel strongly, I am convinced that we need a clerk / tech person, a board clerk. That's who the appeal to the Supreme Court gets filed with, you know, we need that entity. The lawyer is a harder question. Talked to John about it, and, you know, I've tried to pick the brains that have been available to me, and I think it's a tough one. Of course, I would like to say, yes, we want another lawyer because we want to be sure that we have what we need. On the other hand, I know that there is a real desire for us to, if we want to take the active, which I agree with you, I think it would be very good for the program. The question is, at what cost? Are we, if we were only going to do that one step, and the at what cost is, if we're going to put another lawyer on, we're talking about $400,000 a year in, you know, adding to the program costs. And I'm not saying that that's a bad thing, but is it necessary? And if it is, gosh, we need to ask for it. Will we know whether it's necessary later on? Maybe, you know, we may know in 2 years. But right now, I think we need to explain, this is what we think that we will need. Please give it to us if you want us to do this. And then in 2 years, we go a step further. You know, we're phasing, then we can actually see what's happening and give you a more definitive indication.
Well, the other thing I just want to quickly mention is this public comment period is still running.
Okay.
And while we had a pretty robust stakeholder process, like there could be some other new, very compelling information that comes in that we cut along. So
I think there is the promise of additional information tonight, to
Yeah.
consider, so I think, looking at all the information, I think just coming back to it is remembering when we did go to the model of environmental court and transfer everything, and we'll get a second judge and everything will be fine, and we haven't revisited those resources. We are a very people-centric organization. When you have one person out right now, the impact that that has. We are right now operating down with an attorney, and that has had a larger impact on. So I think we are looking at trying to take this on to make it better and have better consistency and move the needle. And so I don't think it's out of line to at the very least ask for a court comment to help with that sort of redundancy within our organization.
Yeah, I think the clerk is a no-brainer.
Yeah.
I think we all agree. Question is, do we get another lawyer? We don't know.
I think part of it is what we're saying, is all house. Sounds like right here on A and B. Sounds like you three are pretty sure about that.
Well,
You sound
just to
okay.
reiterate, I'm pretty sure we do not need another attorney if we're gonna push this out 3 years. I believe the
Yeah.
third attorney that we were granted last year or this year, is sufficient to help us adjudicate these appeals. But I've said that before, so I'm just repeating this.
Which we don't have right now, so it's one.
That's not an issue, that's not,
Right,
that's
I know.
not a passing issue in terms of what the legislature has granted us, that's just an iron issue.
We don't get an extra attorney for when we're down one.
So we're going to assume we can reassign from the Act 181
Staff attorney.
issues that need to be done. And that person can be retooled into an appellate attorney or, you know, however that's the court now. Because we're gonna need 2 lawyers on appeals. And we will have 3. So we have a general counsel, we'll have 2 staff attorneys. And that's, okay, we got 181 out of the way. We're still doing enforcement cases in court. The permitting, we're no longer doing, but we're only a party, and that is not as heavy a lift as being the lawyer writing the decisions on motions. So that's the thing, we have like one attorney, you think the majority of that person's time can be reallocated to appeals. The other half attorney that we get, full attorney, we're not even sure,
Well,
will be our second appellate attorney. We need at least two for conflicts.
I think one of the things that was brought up tonight is exactly that, is we don't have rules right now, in terms of how that will sugar out and handle in terms of conflict of interest. I feel like I don't have enough information at hand to say that we don't need another attorney, because if we are taking appeals, our organization, within our organization, as you said, there still is enforcement. So if you have an attorney that's touched something for enforcement, and then it comes through as an appeal, ethically making sure that there are those bright line, I think you call them firewalls, is how compartmentalized can we become?
Well, and why do we need an attorney for an appeal? Every time.
If there
I mean,
are,
we're the quasi judicial body that is making that decision. Why do we have to have an attorney? I sort of still see this, maybe it's naive, but I see it like a DRB taking an appeal of a lower decision by the zoning administrator. There's no attorneys that need to be involved,
well, half of the stakeholders are going to disagree.
Yeah.
That's all.
And I think,
It's credibility, it's knowing that you have a law-trained judge at some level, because remember, Act 250 is coming from a citizen board. Zoning is coming from a citizen board. And so, and there was a big debate, we were also informed about the legislature did not want this to be an attorney bound board,
Right,
for the attorneys to come in and to take over and run the show.
Right.
My concern is when there are legal challenges that need to be researched and written and responded to and decided. I mean, I can do that, but get me Westlaw. I will be then a practicing attorney, not a board member. I have a different role in this.
Right, so we need
Right.
we need an attorney,
So we need a
But-
lawyer.
but do we need that attorney?
Like to sit there for every
Right.
case and
No, yeah, so,
if, when we hold a hearing, if we are capable of doing our own evidentiary rulings, that would be one task that a lawyer can do. That would be very helpful and beneficial, even if they weren't making the rulings, to advise the board to make, how to make the rulings. Any other issues, if there are procedural, legal challenges that are outside of the, Act 250, creating findings of fact and conclusions of law under the APA, to make sure we have that legal support. So we have to have a lawyer available. They don't
Yes.
sit at every event.
right, and I also want to make sure that we're not disadvantaging our own program. So if you have an appeal of an Act 250 decision and the applicant has brought an attorney or two to the process, I want to make sure that we haven't inadvertently cut our enforcement team and our attorneys at the knees by just depleting our resources and saying, oh, we need our attorneys on this side, and so we can't have an attorney representing Act 250 and the Enforcement Act. I just want to be very cognizant of that, because I think being down an attorney right now, and you can't just call the Attorney General's office and say, hey, do you have a lawyer? That doesn't happen. So, we could max out on some of these larger, potentially, appeals. So
All right,
I feel like I still would like to hear more information. It sounds like there'll be more information coming. I think you're doing your best to work through all the resources, so I'll stay on the fence right now, although it sounds like Alice on one side. I'll stay on the fence right now on that.
okay. You bet, you
I
bet.
am-
Okay.
But I think I have the marching orders for right now. so
Okay.
this is very-
All right,
I'll make a motion to adjourn unless there's any other business.
Second?
all those in favor, please say aye. Aye.
Aye.
That is unanimous. We are adjourned. Thank you, everybody.
You.
Yeah, thank you.
Thank you, John. Oh my gosh, I appreciate you coming down.
Yeah, no, I'm glad I did. It was, thank God more people didn't show up. We'd be here until like 10 o'clock at night.
Some of us could have shortened our remarks a little bit.
I'll take the criticism, Thomas.
No, I wasn't, I was also